So I'm going to do it according to the program here. Our next presenters is Jill Fisch, a longtime friend, fellow academic, a leader in the securities in corporate area. In fact, as I mentioned earlier, Jill took the lead on the Halliburton brief that was written by a larger amicus brief that was written by a larger group of academics than the one I think that Adam, you were involved with, that's a party of two. But I'm sure both sides think that they're victory. So Jill, welcome. So let you speak either from the podium or here, wherever you feel most comfortable.
Okay. What do I need to do to get my slides?
So who's our technology person here is definitely not going to be me.
Thanks for being here. Thanks for inviting me. It's a little bit of a amicus brief reunion, but just to clarify, certainly Jim and Anne did a more than their fair share of the work in drafting our amicus brief. Jim wrote a whole section, and I can't remember how many drafts and how many little comments and typos she corrected, and substantive points as well. So, but what we tried really hard to do in that amicus brief was to come up with common ground. And so I think the point of this conference in part is to allow us to explore each of the areas in which we might have chosen to go off on a tangent but didn't think it necessarily served the interests of the collective whole. That being said, I agree with an awful lot of what the first panel said and an awful lot of what we're going to hear in subsequent comments here, lest you should think that we're all on the same side. The panel after lunch, I think, will introduce the dark side in both Adam's and Amanda's comments. I think they will challenge at least some of our assumptions, suppositions about BASIC, about the value of class actions in private litigation, and so forth. So anyway, so let's go to it. So background, and of course, Anne gave you a lot of background already. Background to Halliburton II is obviously the BASIC decision. And let me just up front a couple of points about BASIC. First of all, BASIC says indeed that plaintiffs have to prove reliance. The lower court cases leading up to BASIC weren't altogether clear on that point. There was some movement in the lower courts that maybe the reliance requirement didn't make a whole lot of sense in public capital markets fraud. And for some of the reasons that Anne said in the earlier panel, I think that's right, and I've actually taken that position in other work. The reliance requirement, at least in the way that it's come out in BASIC, is kind of silly. And therefore, the whole fraud on the market presumption, which is this sort of cumbersome mechanism to create a presumption of reliance because we have a reliance requirement, I think doesn't make a whole lot of sense. BASIC also places a lot of weight on market efficiency. I think that's a little silly as well. And some of the other amicus briefs in BASIC make that, in Halliburton II, make that point. Why is it a little bit silly? Well, the kind of efficiency that you need for BASIC, and Chief Justice Roberts said this in the Halliburton II oral argument, is you need enough efficiency that information affects stock prices. You know what? Information affects prices all over the place, not just in efficient markets, but also in inefficient markets, and also in things that you might not call traditional markets at all. Now, I will grant you there's a body of cases kind of testing the line in the securities market. And one of the big debates is, well, do you have sufficient efficiency in the IPO market? Put the IPO market aside. The IPO market is different. I had an investment banker come in and talk to my securities regulation students earlier this semester about IPO pricing. I'm not sure I knew more about IPO pricing after I heard him speak than beforehand, but the impression I got was quite clear. Information isn't really a big part of IPO pricing. There's a lot of other stuff going on. What that other stuff is, we can debate. There's a lot about the price pop, which, doesn't really factor into your sustained analysis of market efficiency. Anyway, but there's a whole world out there that says, there are lots of decisions in which you have this assumption that people will behave in more or less the same way if the information is different, but the terms of the contract, the terms of the deal, the price of the product could be affected if there's a difference in information. And we cite, I think, in the amicus brief to the restatement of insurance law. And one of my colleagues is one of the reporters for the restatement of insurance law, which is why I know something about this. The restatement, the general rule in insurance law is if you lie when you're trying to get an insurance policy, what the law will do is assume that, yes, in fact, you could have gotten the insurance policy, but you would have paid a different price. You would have paid a different premium. Okay? Now, that's not to say that there's an efficient market in these, personalized, negotiated one-to-one insurance transactions, but it is to say that information affects price. Right? Think about that example when you think about what's going on in fraud on the market and BASIC. But okay, I've put my caveats on the table with respect to BASIC, and I just want to make it clear that I'm not standing up here and defending the basic analysis or reasoning or what it is that the Halliburton II court had to deal with. All right, but there's BASIC, then there's Dura, and Anne talked about Dura, and the key point for Dura is BASIC said, well, you've got a claim if you trade at a distorted price, and I'll expand on what that means in just a minute. Dura said, well, that distorted price isn't enough. You're not harmed just because you traded at a distorted price. Right? And we'll come back to why. Right? So Halliburton won. Halliburton likes to go to the Supreme Court. You love to be Halliburton's lawyers because you get to go to the Supreme Court all the time. Halliburton won, comes to the Supreme Court, and the court has the opportunity to kind of sort all of this out. The court doesn't say very much. Big disappointment, a lot of buildup, and Halliburton II, you might say big disappointment as well. But at the end of the day, the court simply says, well, reliance, what we're talking about in BASIC and what we were talking about in Dura, two different things. And we're not going to explain exactly how those two different things are different because the lower court kind of assumed they were the same, so we remand and we get ourselves out of trouble, right? And then Amgen, again, perhaps an opportunity to sort all of this out. Again, the court doesn't say very much except, well, you don't have to prove materiality at price certification. Therefore, we're not going to explore the relationship or the possible relationship between materiality and causation, materiality and price impact, materiality and all of these event studies that are floating around. So we've got all of these seeds of, well, should I say, confusion? Right? But okay, so we get to Halliburton II. And Halliburton II presents two issues, right? The defendants essentially, issue number one, BASIC should be overturned. BASIC is wrong. Right? Not BASIC should be overturned to get rid of the reliance requirement because it was silly to begin with. That would be my position. No, they were going off in the other direction. BASIC should be overturned so that we don't have the fraud on the market presumption. Plaintiffs have to prove reliance directly, which, by the way, would mean it's almost impossible to get class certification, to have class actions. And let me just cabin, and you can bring us back to this point in case I forget. It's not just class actions that would suffer if we got rid of fraud on the market. So would a lot of direct actions or opt-out cases brought by individual plaintiffs who can't show reliance directly. And if you're thinking, well, what institutional investors are you thinking of? Vanguard, index funds, Index funds don't trade in reliance on the information in the financial statements, whether or not they read the financial statements. They make their decision to buy and sell based on whether the stock is in the index. They're not going to be able to offer direct proof of reliance. So, point number one, basic should be overturned. And the Supreme Court listens to that argument and tells us pretty quickly, for reasons that I'm not going to get into in this comment, no, we're not overturning basic. All right? The defendants have a fallback position. They say, well, okay, if basic's not overturned, at least the plaintiff should have to prove price distortion and class certification. Right? This is one step beyond the argument in Amgen that plaintiffs should have to prove materiality at class certification. And the Supreme Court says, well, no, not exactly, or it's not entirely clear. At least some justices writing separately make it clear, no, that's not exactly what's going to have to happen. No, but the defendants will open the door. We'll take this intermediate position, as Justice Kennedy put it. The defendants can rebut, can disprove price distortion, can introduce evidence in an effort to defeat class certification. And why does the court allow that? Well, Chief Justice Roberts says we should allow this because we've got all of this good evidence just hanging out there that could allow us to resolve this key issue. The good evidence is in the form of event studies. An event study, Chief Justice Roberts tells us, is direct evidence capable of showing no price impact. Why should the court, if it has direct evidence capable of showing no price impact, why should the court close its eyes and say, no, I can't listen to that now. Wait, come back in a month. Right? That would just be silly. So that's the court's reason. Okay, what's wrong with that? Well, price distortion, and I've written elsewhere, price distortion is a critical, I think the critical component of fraud on the market. The whole point of a fraud on the market claim is the plaintiff saying, I traded at the wrong price. Right? But for the lies, I would have purchased or sold at a different price. Now let's think very carefully about what that means. What that means is that in the counterfactual world in which the defendant didn't lie, the price would be different from the actual transaction price. Right? If that's the case, and this goes to the issue that the first panel flagged, if that's the case, the plaintiff is harmed to the extent of the difference between the price at which they traded and the price at which they hypothetically would have traded. And you see how that argument runs into some tension with the court's decision in Dura, in which the court said, no, that's not economic harm, trading at the wrong price, right? Which is why I flagged Dura for you. But this is the claim, right? In this counterfactual world, the trading price would have been different, and at least we should be able to conclude that under the fraud on the market theory, if the price wasn't distorted, if the price wasn't wrong, the plaintiff hasn't been harmed. Now, I also want to be clear about what we mean by distorted or wrong, because this gets us into a little bit of a tricky area, which is one of the reasons that the defendants made this first argument about overruling basic. Right? Wrong doesn't mean the price of the stock reflects or doesn't reflect true value. Right? We have this idea of fundamental value efficiency, that market prices are objectively right. And most people don't believe that that's true. One of the reasons that most people don't believe that it's true is because it's hard to say what it means for prices to be objectively right. Another reason is there's all this economic evidence suggesting that prices can deviate from true value in ways that are, if not entirely predictable, at least systematic. So we worry about this claim that price can reflect true value, and the claim that price is distorted doesn't mean that price is in some way objectively wrong. The claim is just the price is different from what it would have been. Right? But this presents a challenge for the empirical analysis that you might need to calculate the amount of the plaintiff's harm. Because we don't live in the counterfactual world. Right? How do we know? We can't run a trial. We can't go back to before the oil spill and say, well, okay, BP, instead of telling everyone we have the highest level of safety testing, rewrite your disclosure statements to say we have a sort of okay level of safety testing. And let's see what happens to the market price. Right? We can't do that. So we don't necessarily know. Even if we can make the claim, okay, the price would have been different, it's very hard to calculate what that difference would have been, which is, I think, a real challenge to fraud on the market theory and to the court's reasoning in BASIC. But that's not the issue in class certification. That's not the issue in Halliburton II. Because to obtain class certification, the issue is not, can you measure the exact amount by which the price is wrong? You just have to make the claim under a civil law standard that the price would have been different. Okay. So what else is wrong with the Supreme Court's reasoning in Halliburton II? Well, a second problem is that price impact and price distortion are different. Anne gave us the classic example. If a company lies in a way that's consistent with or confirms its prior statements, that lie is not likely to have an impact. It's not likely to move market price. The company says, yeah, whatever we said 6 months ago continues to be true. You wouldn't expect the stock price to react. But if instead that confirmatory disclosure is a lie, if the company had told the truth, the price would have been different. So two different things. Second problem, right? Even if we get it right, even if we understand that what we're capturing is price distortion, not price impact, the standard event study doesn't actually prove that there is no price distortion. And I'll explain what I mean by that. Third, why exactly are we focused on proving price distortion directly? I'm going to talk about the empirical methodology, and I'm going to suggest to you that it's not very reliable. But think instead about the elements of federal securities fraud. One of the things that you have to prove in a securities fraud case is that the lie, the fraud, was material. What does it mean for a misstatement to be material? It means that misstatement is sufficiently important that it has the capacity to affect stock price. So why is price distortion a separate element at all? This is a question that the court could have and didn't address in Amgen, because it decided Amgen based on these Rule 23 proceduralist grounds. But I think it's quite important. And finally, and related to the Amgen point, whatever we think of this issue of price distortion, does it make sense to examine this question at class certification? All right, so I want to talk about all of these 4 points very quickly, now that I've used up all of my time. All right, so price distortion is different from price impact. Here's my little picture to illustrate the point that I'm making. Suppose that's a chart of the stock price, and at whatever time t that is, the company lies. Right? And the company lies to the extent that it says, we expect earnings to continue at current levels. You wouldn't expect the lie to move the stock price. The stock price, in fact, doesn't move. What happens is that sometime later, does this have a little, yeah, see, some point later, the company tells the truth. Whoops, earnings are not continuing at current levels. Oh, and by the way, we knew that at time T1. Stock price drops, right? The people who purchased here at the time of the lie presumably should have purchased somewhere down here or maybe down here, taking our BP example, right? The stock price was wrong. It was distorted by the lie, but the lie itself doesn't have a measurable impact on stock price. All right, so that's my little graph illustrating that first point, right? And of course, if you go out and you do the standard event study, gee, what happened to the stock price around the time of the lie? You will find the event study confirms the lie had no price impact. Does that mean the defendants have rebutted the fraud on the market presumption? Clearly not. I'll let Adam rebut that later. Okay, whoops, didn't mean to do that. All right, BASIC itself was this kind of a case. So this is a chart of the stock price in BASIC, right? BASIC lied 3 times. What did BASIC say to the market? Well, it's kind of like what BP said to the market. BASIC said, we're not engaged in merger negotiations. Turned out they were. They were for a period of more than a year. And the merger negotiations sometimes went well, and sometimes the parties worked away and said, forget it, we're never going to merge, right? And they came back to the table, right? Each time, BASIC lies. Right? And it's true that the stock price likely would have been different if BASIC had instead said, yeah, we're engaged in preliminary merger negotiations. They might not go anywhere. Combustion engineering, we're really very far apart on the merger terms, but we're talking to them. It's likely that the stock price would have been different in the same way that I think it's quite plausible that if BP had said, well, our safety testing it's okay. It's not great. It's not perfect. It's not as good as we claimed it was, but it's okay. Maybe the stock price would have been different. Maybe there were analysts, expert in the industry, that would have said, BP's a little bit riskier company, and as a result, the stock should be trading at a lower price. Right? But the plaintiffs in BASIC weren't really bringing suit because they wanted the difference between $25 a share, the price at which the stock was trading, and the $25.50 a share that the stock would have been trading at if BASIC had said, yeah, we're in preliminary merger negotiations. What the plaintiffs are upset about is that jump up in stock price, right? That jump up in stock price isn't the result of the lie. It's not when BASIC said, oh, yeah, we're engaged in merger negotiations. It's when BASIC said, hey, there's a merger. The stock price here is not distorted by this amount, right? The misinformation in the market a year earlier, more than a year earlier, is not the difference between no merger negotiations and a merger. It's a difference between no merger negotiations and preliminary merger negotiations, which is something quite different. Okay, so maybe I've convinced you that price impact is different from price distortion. Maybe I haven't. Even in the case in which we have a misrepresentation that arguably is new information to the market, not a confirmatory disclosure, and that arguably should affect stock price, the standard event study methodology, what the Supreme Court is talking about in the Halliburton II opinion and in the oral argument, doesn't really do what the Supreme Court and what most judges that I've talked to think it does. Right? What we're looking at here, what the event study is testing, is the null hypothesis. The null hypothesis is that the information didn't affect stock price. Right? Stock prices, as the previous panelists explained, fluctuate. Right? The stock doesn't just go like that. And sometimes, you put everything together. I have my basic chart, and it looks like it's a pretty steady, but they're going like that, right? And stock prices move in response to both firm-specific events and overall fluctuations in the market. In fact, the majority of stock price movement is due to general market movement. Stock market goes up, price of most companies' stock goes up. Stock market goes down, the price of most companies' stock goes down. Right? So there's this market component that we have to sort out. There's the relationship of an individual stock to market movements. Some stocks are more affected by global economic movements than others. And there's other firm-specific information and normal volatility, right? The price of a tech company is more volatile than the price of a utility company. The econometric technique in event studies says what's sort of the normal, what's the predictable range of stock prices? And then let's look at the day of the event and see if the stock price or the stock return is outside of that normal range that we might predict. If it's outside of that normal range by enough, we can reject the null hypothesis. Right? Our finding that there's a statistically significant price impact, right, is an empirical conclusion. This information distorted price. Right? But a return that's within that range of predictable movements doesn't mean the information didn't distort price. It just means this statistical technique doesn't prove conclusively one way or the other. It doesn't confirm the null hypothesis. It doesn't reject the null hypothesis. It's a non-result. There is an empirical test you can do to try to establish, to try to prove the null hypothesis. It's not the statistical test that we see being introduced in these cases. It's a much harder economic standard, right? So the upshot is event studies of the sort that the defendants are introducing here don't confirm the null hypothesis, don't establish the null hypothesis. They just fail to reject it. Right? Now, I said the courts don't get that, right? This is sort of subtle point, right? You're all sitting here, you're law students, you're probably, this is way too much math, and you've already shown me charts and everything, and I don't get it either, so of course the judges don't get it. But it's worse than that. Not only do judges not get this difference between establishing and rejecting and all of that, the judges actually think this hard science of event studies is doing a whole lot more. So there's Chief Justice Roberts again, and Chief Justice Roberts, at oral argument, says to one of the advocates, can I ask you a question about event studies? Can they distinguish between an appropriate response to information and an irrational reaction to the facts contained in the disclosure? And Chief Justice Roberts is told, yes, event studies are very effective at making that kind of determination. Don't believe it, right? Can event studies tell you why the market moved the amount that it did, or whether that amount is the correct response, the correct incorporation of that information? We'll know only if event studies, only if the market is fundamental value efficient in a way that we've all agreed it's not. Right? And all of that literature that the defendants introduced about noise trading and irrationality and overreaction by the market and so forth is why event studies, in fact, can't answer this question. So putting event studies on the table and saying, yes, this is something you can do and should do at class certification is a little bit dangerous, is a little bit scary in the hands of judges that don't really understand what it is the tool can do. Right? So, and I'm gonna move more quickly. I've already kind of made this point. So my argument in this paper is, as a result, we shouldn't go down this path. We don't need to go down this path. We're already making this calculation at least to a degree that is sufficient for class certification if we simply make a determination that the misinformation is material. Right? And yes, Anne talked about, the mutual fund example, and, it's a lie, but it's a lie about the fund's composition. It doesn't mean the price is wrong. Yes, there are limited circumstances in which you can have a material misstatement that doesn't affect stock price, right? I grant that. They're the rare cases. They don't tend to be the standard straight security cases. They're, mutual funds or hedge funds or other kinds of investments. Put them aside. Don't worry too much about them. We can always come up with a way of handling the exceptional case. Right? So materiality, I argue, should be sufficient, should get us far enough to meet the requirements of the basic presumption. Does this mean Amgen was wrong? Well, it depends. It depends in part on what this class certification hearing is all about. And here I think Anne was exactly right. I think the court, and it's not just in the securities area, but in general, thinks that class certification should be this important gatekeeping device, right? And there were a lot of questions again at oral argument. Well, what percentage of classes are being certified? At what percentage of cases does the class certification result in getting rid of the case? Like, this is some sort of meaningful inquiry. We're talking about public capital market securities fraud. And we're talking about plaintiffs that are not going to bring the cases in the IPO market or the cases in the pink sheet market where they can't meet the efficiency standard. We would expect close to 100% of these cases, when you're talking about New York Stock Exchange listed companies or NASDAQ companies, would be certified, would proceed forward. Now, it's true that outside of the securities area, we've seen a big pushback. Right? Courts are front-loading the inquiry, are making it harder to certify classes. We have cases like Walmart and Comcast, non-securities cases. But I would argue that securities fraud is different. Right? And BP is another example. Why is securities fraud different? Well, we've got all sorts of other distinctive gatekeeping devices. We don't need class certification to do this work. We've got the pleading standard. We've got the motion to dismiss. We've got the discovery bar, right? We've got all sorts of stuff that allows you to weed out, to separate out meritorious cases, to reduce exploratory discovery and all of that stuff and settlement pressure. And I'm out of time, but that's okay because I'm almost done. All right, I'm almost done. Anyway, I really am almost done. This is it, right? But just because I'm arguing we shouldn't do this at class certification doesn't mean the issue of calculating damages and quantifying damages based on this price distortion theory isn't critical, right? So that's something I'm going to flag. It's something I'm not going to talk about because the hook has already come out. But I leave you, and I leave the courts with the need to focus on that critical question. Done.
Thank you, Bill. There's a lot to think about there. Now the lights come on. James emerges from the saddle. UCLA. He's now waking up body.
That's right.
Particularly for you.
It's almost 9 o'clock in
the
LA.
West Coast for the crowd. Welcome.
So as discussed earlier, the fraud on the market presumption rests on a couple of different propositions. The first is sort of the descriptive proposition that efficient markets react to publicly available information. That's a question that the financial economists have debated and tested over time. The second, which I'm going to focus on in my talk, is more of a normative question. Should investors be able to reasonably rely on the assumption that markets have integrity? Right? Do markets have integrity? Should investors be able to rely upon that assumption? And this, I think, was one of the more hotly contested issues in the Halliburton opinion. There were some extensive discussions, and it was also contested in BASIC, but I'll focus on the second Halliburton case's discussion. And the dissent is pretty dismissive of this particular argument. Justice Thomas says that BASIC's assumption that all investors rely in common on price integrity is simply wrong. And there's sort of an intuitive appeal to this argument, right? I mean, market prices, as other panelists have noted, fluctuate all the time, right? They fluctuate on an hourly basis, a daily basis. How could an investor believe that the market has integrity? On the other hand, it seems odd to me, and I felt this reading the petitioner's briefs, to say that the market is just totally lawless, right? Totally random and just lacking totally in integrity, especially given the effort over the past 10, 15 years to improve the integrity of the public corporation and the disclosures that are coming out of the public corporation. Could greater expectations with respect to what a public corporation is about translate into another basis for a reasonable reliance? And that's sort of the argument I'm going to try to sketch out today. I'm trying to shift the discussion from whether or not markets have integrity to whether or not the public corporation has integrity. So sort of to set up the theory, I have to show why the prior theory is not as strong. And I think Halliburton it does a valiant job of defending market integrity, and Justice Roberts brings out some additional examples that were not present in BASIC, but I think that these are questionable examples. The argument is not as strong as it could be. And the primary debate is about the value investor that Professor Cox mentioned in his talk, and the existence of the value investor. What implications does that have for market integrity? Because the value investor buys stock not on the basis that the price is accurate, but on the explicit basis that the price is inaccurate, that it is below the fundamental value. And so the existence and success of the value investor really questions sort of the idea that we can really believe that markets have integrity. And one of the interesting things about the opinion is Roberts gives a sort of a specific response to this argument, and he says, well, even the value investor assumes eventually that the market price will recover to its fundamental value. What does he mean by that? I've been sort of puzzling over that particular statement. I think one reasonable interpretation of this is, well, maybe even value investors believe that there's some rationality to the markets, right? Some basic rationality with respect to market prices, and that they, over time, will eventually become fundamentally efficient, and that supports the idea that markets generally have integrity. It's a pretty decent answer. But on the other hand, it seems unclear to me, though, how the value investor in that particular example is really harmed from fraud, right? How is the value investor harmed if the price does not recover to its fundamental value? And that's sort of a question that's kind of left unanswered. There might be a sort of an expectation there, but is that something that would give rise to a securities fraud claim? And I'm not sure that it would be. And so I hope that an alternative approach might answer some of these questions as to how the value investor might be harmed. And now certainly we could defend a weaker view of market integrity, one that relies upon the absence of fraud, as Professor Fisch has articulated in her presentation and an article in the Washington University Law Review. Maybe it's sort of just the weaker view that maybe what market integrity means is that there's just not pervasive fraud in the marketplace, and that we're buying stock that's not inflated by fraud, because if there wasn't fraud, the price of the stock would have been lower. There are some skeptics, even among supporters of the fraud on the market presumption, about this theory. Professor Donald Langevord has written a famous article that's been cited many times in this debate called Basic at 20, and he sort of says, well, can investors really make that assumption? Right? When I buy stock, shouldn't I assume that there's some fraud baked into the market prices? Shouldn't I be aware that companies commit frauds, that accounting standards are manipulable? And so there are good responses. I ultimately don't find that persuasive, and I think that you could support the fraud on the market presumption based on sort of the weaker form of market integrity, but there is a case that maybe we need sort of a stronger basis for the idea of reliance in market integrity. There's a growing literature on the gap between public and private companies. Some of you have studied the Sarbanes-Oxley Act, which imposes greater requirements such as stronger internal controls requirements for big public corporations, and there's been a lot of controversy about whether that's a good thing or a bad thing, but I think many commentators would agree that we expect more of public corporations. Professor Donald Langevord and Robert Thompson have a nice article about how public companies are really sort of big companies these days, and that's sort of what the securities laws are kind of regulating towards, and that there's a growing gap between these big companies and the smaller companies. Professor Hilary Sale has a very nice article about the public's expectations with respect to public corporations and the intolerance of the public for bad behavior by public corporations. And so there is something in the air that there are higher expectations with respect to public corporations. The law and social norms play an important part in drawing the line between public and private companies. There are two major screening mechanisms that a company has to pass in order to be a public company trading on a public market. The first is the exchanges have to accept you to be traded on their exchange, and they have all sorts of listing requirements that a company has to comply with, and exchanges will delist companies, right? Professor Pritchard has an article about the exchange as a regulator and the incentives of exchanges to screen out the bad companies over time, and we see, Radio Shack is a recent example, although, they've been going into bankruptcy for a long time, but they are recently delisted, no longer qualifying as a public corporation. The securities laws also play a pretty obvious role in policing the line between public and private companies. You have to be able to produce audited financial statements every quarter or every year, right? And you have to get an auditor to sign off on your financial statements. Some companies are not able to do that, and they as a result, they cannot be traded, and they fall out of the rank of public corporations. And I mentioned the internal controls processes that have become more and more stringent over time, reflecting a belief that public corporations should have more accurate financial statements. So it may be that the reliance interest that investors have may not be on the idea that the price is exactly correct, right? A few of our panelists have already kind of mentioned that. It's hard to really defend that any investor thinks that the exact price is correct. But could we defend a broader reliance interest in the belief that if a company's trading on a public market, it meets certain norms and laws determining that the company should be a public corporation? Could we have a broader reliance interest in that? And I think a lot of investors would make that assumption to some extent, and even an index fund, right? If you're buying shares of stock in a public corporation, you believe that it's meeting certain qualifications to be a public corporation. How can that reliance be disruptive? I think it's clearest that such reliance is disruptive by fraud that's hiding developments that would indicate a fundamental change in the nature of that particular corporation. And so to the extent that you have fraud that's hiding information indicating that the company is on its way to be delisted, that seems to be something that would violate that particular reliance interest. To the extent the company's heading towards bankruptcy and the fraud is hiding that in the last period, that seems to disrupt the reliance interest. Maybe even a credit downgrade, right? To the extent that a company would have been downgraded by the credit rating agencies and the fraud hides that, that seems to affect a reliance interest such as that. These are the big frauds, the large, most significant frauds, and that might explain, well, how does the value investor get harmed by fraud? Well, it may be that even if the value investor thinks that they're buying at a bargain price, that the company is even in more trouble, and that it should not be a public corporation. It's on its way to bankruptcy, and the value investor can then suffer losses. And in that case, the value investor might still have a claim for fraud. I think ultimately what may have saved the fraud on the market presumption is the big cases, right? The Enrons, the WorldComs, the Global Crossings, all of which arguably hid developments indicating that they were heading towards bankruptcy or some other financial calamity. And I'm certain Justice Roberts probably reads the Wall Street Journal, and he's aware of these big financial crises. And so that might be why he took a somewhat conservative approach in maintaining the fraud on the market presumption, even though the rationale for market integrity may not be that solid. So shifting to sort of an integrity of the public corporation view of things would leave certain cases on more solid footing, but it would also be an argument, though, I think, for dismissing some of the smaller frauds. And the case, I think, so there's something, I think, for everyone here. There's something that supports the people who think the fraud on the market class action is a good thing, but also provides some limiting principles to these particular cases, right? So certainly some of the smaller frauds that involve just fluctuations don't really disrupt the reliance interest on the belief that the public corporation has integrity, to the extent that they're just minor fluctuations. This might be an argument that if investors are relying sort of on this idea of the integrity of the public corporation, that smaller fluctuations may not disrupt that particular reliance interest, and that might be a stronger argument for materiality arguments, whether they're at an early stage or a later stage, to dismiss some of the smaller cases. Now, that might be troubling to some, but it might be, smaller frauds often are related to larger frauds. It may be troubling to allow some of the smaller frauds to go unpunished with respect to private class actions, but these are the sorts of cases where the SEC may be able to play a role in bringing enforcement actions when there is not a strong monetary incentive to do so. The SEC has more resources than private class action attorneys. They are very good at processing the smaller cases. And so for the smaller frauds, it may be that's where we need a government regulator to be filling in the gaps. And so we might have sort of a two-tiered system of securities enforcement with the really big public frauds that affect public corporations and so forth, and have private securities class action attorneys bring those cases using fraud on the market claims. And the smaller cases would primarily be brought by government enforcers. So this it's a very sketchy theory, I know, but I wanted to offer an alternative because sort of the idea of whether or not investors really believe the price is the right price is one that is very questionable, and so I think that there's a need to sort of fit in the Rule 10b-5 class action to the broader scheme of regulation, which is, I think, undeniably moving towards a view of the public corporation that assumes that there is a certain level of integrity to corporations that are public and traded on exchanges. Thanks.
So while I'm transitioning to the front, if I could quickly ask each of you a question, and others be thinking about questions they want to ask. Jill, so crisply and succinctly, if you're presiding over a securities fraud case where there's lots of claimants, okay, tell us how that's going to happen under your vision of the law. I mean, what do you want to have happen in your court, and the process is going to happen? You know, the complaint's there, we're going to have a motion to dismiss, we're going to have a class certification issue like that. And what are we going to do about reliance?
If I'm presiding?
Yes, exactly.
Well, I'm bound by the Supreme Court.
No, you're not. No, you're not, because you're not only presiding. The reason you're presiding is that you are queen for this proceeding, okay? Awesome. So you get the rule, okay? You're on a colleague, so I just want to know, totally clean slate. How are we going to do this?
Well, if I get to rule.
Yes, absolutely.
Then I say.
I've known you long enough not to have otherwise, okay?
Then I say plaintiff pleads materiality.
Uh-huh.
Plaintiff meets the necessary standards in terms of the pleading requirements. That's enough to certify the class. And you know, whether you dismiss on pleading grounds or something else, that's a different question. But class certification is not a gatekeeper here.
Okay, and so then you're going to certify the class, and you're going to leave the parties to their own devices, right? I mean, they're going to negotiate probably, right? Or go to trial.
Well, again, I mean, I think that you carry a lot of weight with respect to the pleading stage and the motion to dismiss. I also think to the extent there are issues about the damage calculation, which I think both the parties and the courts should think more about, there's room to do that with summary judgment. You don't have to go to trial.
Okay, fair enough. And then, so on on the broader reliance issue, I wonder if it could, some part of that could be the idea that if you do have this presence of a huge number of institutional investors who have fiduciary obligations to their beneficiary, whether it be an insurance company or a mutual fund or a pension fund, okay? They have these fiduciary obligations about investing. Whether part of their reliance is not just on the overall integrity of the management, but they have to have some belief, okay, about how prices get established on average, okay? And whether that is a reliance interest that would be, otherwise, I don't see the, do either of you see the Supreme Court ever sort of say, oh, you know what, we're not gonna have reliance, okay?
No.
You know, so we agree that
Yeah.
there's gonna be, the question about how you can define that in a way that makes sense, right?
Yeah. I mean, I think that's right, that everyone has sort of different beliefs about how they're going to make money over time, and certainly, you know, institution will have some belief about how markets work in terms of applying that strategy. And I guess I don't believe totally that we should abandon the idea of market integrity, but it seems to me that all of those strategies are founded on the assumption that this is a public company that should be traded and should be valued, right? And so in some ways, I think this might be a way of kind of unifying all these disparate strategies which rely, you know, which you can't really unify in a sense, right? Some people are value investors, others are growth investors, others are day traders, others are index fund investors. And so to sort of come up with a single theory of market integrity, I think is difficult as a result. But I do think every single one of those investors is only investing in public companies, or at least if you're a certain type of fund, right? And so to the extent that the company should not even be a public company, now that's kind of where it's difficult to draw that line, right? And I'm not sure this could ever really translate into doctrine, but I do think that it's sort of a support. I mean, it's sort of, you know, it sort of is a foundation, I think, and to sort of kind of dismiss the idea that there's any integrity, that it's ridiculous, I think, is what I'm trying to push back against and say there's a sort of core portion of the stock price that relies on a notion of the integrity of the public corporation.
And just to be clear, I'm not arguing or accepting this idea that the reliance on price or price integrity is the right way to structure this cause of action.
Yeah, I think I think Ann and then Alan. Yeah.
Adam, too.
Yeah.
Fraud created the market.
It's a good question. I mean, there are a lot of similarities there, I think, and I should refresh myself a little bit about that area of doctrine where without the fraud there would be no market, I guess. But my understanding of that doctrine is it applies mostly for stocks that are not traded on exchanges, and so there's sort of a sense there that without kind of the sort of the fraud, there would be no, market at all. I think there's sort of less of a belief, though, in integrity in those cases, right? So I think in some ways they differ because one is kind of in a particular setting of private companies and inefficient markets, I guess. And I think that, to the extent that a public company does trade in an efficient market, there should be a higher kind of assumption of integrity compared to sort of the fraud created the market cases. But I'll have to think about that a little bit more.
Adam.
So I think you're both wrong. James, I think market integrity is a fine idea, and maybe it is a value we should be pursuing. It has nothing to do with reliance, right? So you have a normative view that public companies should be sanctioned for making misstatements. I think that's a defensible normative view. That has nothing to do with reliance. Reliance is you caused me to do something, and as a result, I changed my behavior. So the logic of your proposal, I think, inexorably leads to eliminating the reliance requirement, which is a perfectly sensible thing to do if you believe companies should be sanctioned for making misstatements. You should sanction companies for making misstatements. A smaller point on the SEC maybe going after smaller companies. That is a great theory as a matter of public policy. Given the structure of the anti-fraud regime, they should. It is not what they do. All right, the SEC, if they are going after an investigation that class action lawyers are not willing to go after, those companies are bigger on average than the companies that class action lawyers go after. So it is not sensible anti-fraud policy, but it is what they do. I think it is probably what they do because bringing investigations into small companies does not make headlines, and therefore it's not worth their while, and small companies pay small penalties, and if you get small penalties, you don't get a promotion. So if you think that's what they ought to do, you need to propose a structure that will induce them to do that. Jill, you were wrong on materiality. Materiality is not the same thing as price distortion. It is a defensible view of what materiality should be. It is not what materiality is as practiced by the courts. There's all this corporate governance nonsense that the SEC believes is really important, and courts say, oh, well, yeah, it's corporate governance, that investors don't care about, but it's material, right? Conflict minerals, according to Congress, where you get the precious minerals for your cell phone is material, according to Congress. They're wrong about that if it's a matter of does it affect prices. Materiality is both broader and narrower, right? We see broader, this normative notions, and that's fine. But it's also narrower. We see information comes out, it moves the stock market, right? And the courts will still sometimes say, but it wasn't material. Right? So there's this volume of trading, the price changes, but apparently it's not material because no reasonable investor would consider that important, even though all of those investors apparently did. So if the materiality standard were like you said it was, then I think your argument would hold up, but it's not.
Equal time, and then we'll say Carl.
I mean, your point is well. I mean, the reliance element would certainly be much weaker under my my proposal. But I think that I would disagree with you that there is no reliance element left. I mean, there is, there is some reason why companies or investors are willing to invest so much in the set of companies that are public, right? And to the extent that I invest millions of dollars in Enron, believing it's a safe public company, and it shouldn't be a public company because it should be it's heading towards bankruptcy. It seems to me that there's some reliance interest there. I know it's not a well-defined interest, but on the other hand,
you keep using the qualifier interest, and I think that's telling.
The interest of the investor, or what?
You're not saying it's reliance. You're saying it's a reliance interest.
Yeah. I mean, I guess
you're making it as fuzzy as possible.
Yeah. No, I mean, it's fuzzy. It's certainly fuzzy, and I guess it just do we believe that the fact that a market is that company is traded on the public market, does it mean something? Is there some implicit representation that the company is making by being on the public market? And to the extent that there is an implicit representation, it seems to me that there should be some reliance on that, I think. And then, I guess, reliance goes back to, are you making some representation? I think every company that's trading on a public market is making an implicit representation that I deserve to be trading on the public market. And to the extent there is a representation, it seems to me there must be reliance on that.
Materiality?
Yeah, so I mean, I think that you're right. The connection that I'm drawing is really materiality in the context of the fraud on the market cause of action, which is a cause of action that I'm not wholly comfortable with, because I think that in the sort of common law fraud space, materiality can be conceptually quite different. It incorporates Anne's example. It incorporates cases in which it's not just that this higher risk means I would have paid less. I don't invest in companies with this amount of risk. I would have chosen some alternative investment. So I grant you that, and I also grant the fact that our existing disclosure obligations have some overlap with this theory of materiality, but it's a highly imperfect overlap. We can debate conflict minerals.
Alan.
So I don't know how much time we have. It's terrible to ask the question right before lunch. But it occurs to me, and maybe this is more a mind game than anything else, that there is no securities law professor who professes that the fraud on the market theory and the securities fraud class actions are coherent. Nobody will say that. Instead, what we have are this whole cottage industry of everyone saying, this is incoherent for my particular reason. And that leads, for me, to this thought question, a kind of Rorschach's test. What is it that you think would be coherent? Because if you say it's incoherent, it means that you have a theory of coherence. And I think that the British petroleum case, the BP case, is a great place to test this question, this Rorschach's test. What would you think should be the result of that kind of case? And and it's so interesting here. We have three different perspectives. Jim Park's perspective is, as an investor, this is what I think about this case and how I invest in public markets. And Jill, I nominate you not as queen, as empress of the system, and get to decide the case both at a sort of, a procedural, legalistic level, but also at a policy level. And then, Jim, you would only decide this at a broad social policy level about how the securities laws achieve, broader questions of management, goodness, and questions of how markets really, Ben Graham said it all. Markets are at the beginning voting machines, but in the long term, they are weighing machines. And I think our tension here is that we want our markets right away to be weighing machines, but they can't be. So I have no request that you answer this question because
I was getting ready to say yes.
I guess I think it's kind of about paradigm cases in certain respects, in that you have these cases where, over time you discover this is the harm of fraud, the Enrons, the WorldComs, et cetera. And to some extent, my approach is, let's make sure we can target those cases while letting this, I don't know if it's coherent or not, but that's kind of my belief of how it should work. And to the extent that, you kind of come up with a theory afterwards to eventually justify that, I feel like that's what to me kind of drives what I'm trying to do.
And Enron is different from BP.
Actually, I would disagree with that, but just the point, I actually think that the whole purpose of fraud in the market or private actions, whether you have them or not, is to ask a much more global question, and that is, how would you make markets better tomorrow by whatever you make decisions today in terms of what the law does in terms of enforcement. So, if we thought there was a way of taking people out and shooting them perhaps for telling lies, then I think I'd be put on the table the possibility if they could get rid of fraud on the market, okay? Did I put that in the constellation about, I think that's what the name of the game is. I think, none of us have mentioned the paper. Maybe we talk about it at lunch. We need to go pretty soon, right? But, Urska Velikolga's paper, which the first attempt to systematically look at lots of different areas about what the cost of fraud is to a multi-trillion-dollar economy. And that's what we should be concerned about, isn't so much how many people you take out and shoot, but the question is whether taking them out and shooting them makes it better for a larger group, and that's the trade-offs. And so we all have different ways of thinking about what we might want to achieve that. But I think we'd all agree, one, it's time to go to lunch, and two, that there's lots of room for improvement. Thank you all for being here.